Good evening, ladies and gentlemen. I welcome you to my channel, Kenny School of Law. If you have not subscribed to this channel, please do. We will be having a discussion this evening, and my discussant is Dr. M.A. Lateef. Dr. M.A. Lateef is an experienced Nigerian lawyer and a law teacher. He is presently a postdoctoral visiting scholar at Columbia Law School, Columbia University, New York, USA. Dr. Lateef, it's nice having you.
Mr. Adegbite, my pleasure being on your YouTube channel. Thank you for inviting me, sir.
You're welcome. As I said, this evening we'll be talking about should academics be appointed as judges in Nigeria? That is what we are going to be talking about. I know you are quite familiar with administration of justice in Nigeria. It's an area that you have been involved for many years. And I know that you have your stand on this issue, which you are going to share with us. Because in recent times, some appointments were made to the High Court bench, especially. And we noticed that some of the appointees happen to be law lecturers like you, and some full-time legal practitioners. I'm talking about courtroom advocates. They have this sentiment that lawyers coming from the academia may not be that good on the bench, given the fact that they don't have the courtroom experience. So I would like to know your own response to that. But let's start this way. Can you briefly tell us requirements for the appointment of judges in Nigeria?
First again, thank you for bringing me to your YouTube channel. The requirements can be found in two important documents, and I shall state them in the order of their importance. The first and foremost, of course, is the 1999 Constitution of Nigeria, which is a ground norm, the fundamental law, for the governance of Nigeria as a state. So under Chapter 7 of that law, which is titled the Judicature, the Constitution clearly stipulates the requirements for appointments onto the benches of the what we call Court of Records. And of course, starting with the Supreme Court. So the basic requirement, which cut across all of these courts, I would say the Supreme Court, the Court of Appeal, the Federal High Court, the National Industrial Court, and then up to the State High Court. And of course, there are other courts like the Sharia Court of Appeal and all of that. So the first one being the Supreme Court, Section 31 prescribed in particular that for a person to be qualified to be appointed as a Chief Justice of Nigeria or as a Justice of the Supreme Court of Nigeria, that person is required to be, one, a qualified legal professional in Nigeria, and two, who has been so qualified for at least a period of not less than 15 years. Then, when you move further under the same section, then you the one for Court of Appeal stipulate 12 years, the one for National Industrial Court stipulate 10 years, and so on and so forth. Now, from this constitutional background, it's quite obvious that the basic requirement is, one, to be a qualified lawyer in Nigeria, and two, to have been so qualified for specified number of years and depending on the particular court. So that is a basic document, and there is nothing more to appointment under the Constitution. Then the other document, which I think is a secondary legislation here, is the NJC rules. By the way, the NJC is the National Judicial Council of Nigeria, which is a body that regulates the judicature of the country. So the NJC, exercising its power under the Constitution, has over the years formulated rules. Now, under these rules as well, there are other requirements. And of course, this requirement also derive from the constitutional one that I stated earlier. But the key or the most important of this requirement is that to appoint a judge of the State High Court, for example, the chief judge of a state as a chairman of the State Judicial Service Commission, make a recommendation to the governor and send that recommendation, up to the NJC, who then return. So there is a lot of back and forth. But basically, that document goes further than the basic requirements under the Constitution by stating, for example, under paragraph 4A to D, I think, that the persons who shall be so qualified are persons who exhibit certain qualities. Paragraph 4A, for example, lists integrity, knowledge of the law, capacity, experience, and all of that. But when you go to paragraph B, the first requirement is that such a person must be a legal practitioner, someone who has been in active legal practice. Then paragraph C also lists the registrar of courts and then magistrate. Then when you go to paragraph C, then it states that persons who have also been teaching in reputable academic institutions and who have record of research that are truly scholarly. So if you ask me, basically from the provision of the Constitution on the one hand, and then the NJC rule on the other hand, the requirements are clearly specified. I don't think they are cumbersome, and I don't think they are misleading. So if you look at this document alone, you will realize that perhaps the debate that we have witnessed or that is still ongoing in recent time may not actually be so necessary. Necessary because the paragraph 44D or C that I pointed to earlier actually recognizes the fact that an academic, a law teacher or law professor may well be appointed, to become a judge of a law.
Oh, Dr. Lateef, thank you. I don't know if you are hearing me.
I can hear you very well.
Oh, good. Yeah, yes, I got I really like your reference to the NJC guidelines or rules. Now, there is something that you mentioned there, which I want to call your attention to again. Now, okay. You talked about legal practitioners, and then you talk about law officer as well. Now, let me read a place to you. I didn't number it the way you have referred to them in terms of paragraph A or B or C. Now, there is a place that says satisfactory and consistent display of sound and mature judgment in office as a chief registrar or chief magistrate. You referred to that. Now, talking about academic scholars, law teachers now, it says credible record of teaching law, legal research in a reputable university and publication of legal works, and in addition to any or all of the above. So why in addition to any or all of the above? Are you saying that in addition to any should not be countenanced?
Well, I think it's a matter of interpretation. It depends on how you see it.
Okay.
So for me, really, I think that paragraph alone can be interpreted independently. However, whatever the rules contain will be taken in the light of the constitutional provision, which I think is a basic guideline, such that if there's any inconsistency in the rule, for example, which is subsidiary legislation, okay, the Constitution will normally prevail. And as I said earlier, the constitutional requirements are basic. And I tell you what that simply means is that, one, if you are qualified to be a lawyer in Nigeria, and then being so qualified for a required number of years, the Constitution did not say that you must have been practicing. So the idea of importing practicing or making practicing as a lawyer the most preeminent requirement is something that may not actually be well rooted in law. I think it is rooted more in sentiment. And which sentiment is that the lawyers who go to court, who have interactions with the law on a daily basis, they get used to that routine, they tend to understand the law better, and they tend to understand the application of the law. But I think there are many flaws in this particular reasoning. One of such flaws is that I think it is wrong to assume that understanding the law or the application of or understanding the law, is only possible for those who go to court or those who practice. The fact is that if there is any legal scholar or a qualified person who deals with the law more than the academic, I don't think there is any. That's what I'm trying to say. The point, the legal scholar, they engage in research, they engage in teaching, they review case law, and they do all of that. So my point basically here is that I think the confusion, as it were, that we have now derive from this misconception about those who practice alone, being the only competent persons who may become excellent judges. So I think that is actually a wrong way to start with. So I think the focus should be on merit. And wherever that merit is found, be it in the academic, because the point is that the trajectory of legal career after being qualified as a lawyer transcend just being a court-going or a legal practitioner. After being called to bar, after becoming a lawyer, many go ahead to become, I would say, law teachers. They go into the academic. Many go into businesses. So the point is, in appointing judges, we should rather focus on competence, on integrity, and those other requirements, such that wherever the merit is found, be it in the legal practice, and of course, they are quite abundant there, be it in the classroom, and there are quite many of them too, be it even in the corporate boardroom. Look at the jurisdiction of the Federal High Court, for example, under section 251. That's a very broad and complex jurisdiction. That of the National Industrial Court as well. This jurisdiction reflects diversities in terms of the kind of issues that go before those courts. So the important thing, therefore, is that the composition of our judges should also reflect that diversity, such that you don't just appoint people from a monotonous, I would say, pathway. Particularly at the appellate court. If you are appointed to the appellate court, I think it is more desirable to have people from different backgrounds, people who have or who deal with, theoretical aspect of law, who can as well also combine the legal aspect, so that when you have a 3-panel of Court of Appeal justices, for example, or 5 of them as the case may be, or even the Supreme Court, you will have people from different and diverse backgrounds. So, and I think, so these are the kind of issues that I think many people don't really pay attention to because of the misconception that understanding the law, is limited to people who go to court every day. By the way, the role of a judge or the skill set of a judge, if I can use that phrase, is not necessarily that of an advocate, which a court-going lawyer does. It is not that of a solicitor per se. It is that of an adjudicator, someone who presides over a proceeding and who then provide formal reasoning or judgment, to adjudicate and settle matters and issue. So your competence or otherwise, and as an advocate, for example, or a solicitor, may not necessarily be the only requirement. So if you can display, for example, the kind of rigor, the kind of intellectual rigor, the kind of logical reasoning, the kind of capacity, and of course, we take for granted that you must have, impeccable integrity. So if you can exhibit those things, again, like I said earlier, wherever you are found, I think it is, wherever such a person is found, be it in the classroom, like I said earlier, or in the legal practice, or even in the corporate entity, should be attracted to the bench. And we've had similar experiences, if you want me to go into that, in the past. And I think it is this previous experience that has helped the recent resurgence in going back to
Dr. Lateef, maybe before you go into that, let me quickly put this across to you. Okay. Now, I don't know whether you will agree that what the academics do and what lawyers do are different. When I say lawyers who go to court, practicing lawyers, what they do are different. There is what we call the substantive law, and there is what we call procedural law. Now, are you saying that there may not be any difference between the performance of a person who has been practicing, who has been a court-going advocate, and the one who has been teaching law, who has always been in court, who does not even know how to draft a motion, who cannot move a motion, who may not even know how to address a judge in court? Are you saying if both of them are appointed, there may not be difference in terms of their judicial performance?
Well, I think I want to answer this by going into history, if you permit me.
Okay.
And I think, like I was trying to explain earlier, you see, the recent resurgence in advocacy for appointing legal scholars, I think, stem from this particular history. If you look at the quality of judges, and I'm sorry to say this, and even the quality of judgment that we have this day, and with due respect, some of them are so bland that they are barely engaging compared to the quality of judgment that the like of Teslim Olale Elias of blessed memory, or even Nokitobi of blessed memory, they deliver in those days. Why do we still keep referring to them? These are, if you ask me, I mean, two of the finest legal minds that I've imagined, I've ever imagined, from Nigeria. Teslim Olale, for example, and then Justice Nikitobi. These two of blessed memory, they proceeded from the academic. And I don't know, of course, they have peers who also, became very excellent in their work. You have Chukwudifu Okuta, who later came after them. You have Kayode Esho and the like of them. But I'm saying, when you talk about the finest legal mind that have graced the bench of the Nigerian judiciary today, you cannot but mention Teslim Olale Elias, for example, who was appointed directly to the Supreme Court of Nigeria in 1972, even as a Chief Justice, or Nikitobi, who was appointed to the Rivers State High Court as a sitting Dean, Faculty of Law, University of Maiduguri, and DPC academic in 1985 or so. So these people, so my point basically is this: fine, the lawyers who are strictly in legal practice, they understand law and they do so well. And of course, some of our judges that we also reckon with today, emerge from that spectrum. But I'm saying the requirements of being an excellent judge, which are the thing I've laid out earlier, is not restricted to legal practice or those who are in active legal practice alone. That's why I said wherever the merit can be found, and some of them can be found in the classroom. I do not want to mention names. If you go to a national industrial court today, some of the finest judges that you have, one, are those who are either directly appointed from the academic or those who have gone ahead to receive further academic degrees like PhD and all of that. So all of this attests to the fact that what we should do basically, again, is to focus on merit. And as I said, wherever that merit is found, okay, that is where we should,
Okay.
go and...
Okay. Yes, Dr. Lateef, you've really made that point very strongly. But now, let's look at it this way. There was a time I was in a court, and there was a proceeding, a trial was going on, and a lawyer stood up, a lawyer from the opposing side stood up and said the witness of the claimant has to go out of the courtroom because he's a witness in the case, even though this particular person was also a party in the case. And the judge said, okay, the person should go out. And his lawyer stood up and said, no, he's a party in the case. He ought not to go out, even though he's going to give evidence that he can stay. And the judge said the person should come in again. And the impression created was a judge who did not know, who is not familiar with the courtroom. So don't you see that with people who come from the academics, who don't know, who are not that familiar with the courtroom procedure and events, if I may put it that way?
Okay, well, I wouldn't know this particular judge of your reference, and I wouldn't know the background and all of that. But the point I'm trying to make is that, I've emphasized on merit. If a judge is truly deserving of that appointment, wherever that judge is found in the academic, naturally they will go ahead to exhibit or justify their appointment. And of course, the fact that a judge also makes a mistake, they are human beings. Don't let us forget that. And the fact that a judge makes a mistake of procedure does not necessarily mean that that judge is not sound. Perhaps there was some misunderstanding, of the law at that point or something. But the point I'm trying to make is that the competence of a judge, or how a judge, or how excellent a judge may be or is not necessarily, or should not necessarily be restricted to those who are in active practice alone. Again, like I said, merit should be our watchword, so that wherever that merit is found, And I tell you, they are banned in the academic. And this is why I want to say I applaud the recent, development in our judicial system. I'm basking on that issue that I was trying to refer to earlier. Well, I hope that going forward, some of these people will also justify, their appointment, like those who preceded them, the Elias, the Nekitobi, and quite a number of other ones that I don't want to mention.
So, Dr. Lateef, if I get you very well, the experience, the merits that you are talking about, you mean the constitutional requirements in terms of social number of years as a qualified lawyer. I think that's what you're talking about. So,
yes.
So you don't see place of experience in requirements for judicial appointments.
Oh, no. You see, when I say merit, I actually mean that we should, one, of course, the constitutional requirement is taken for granted. We know that is a requirement that must be met. And of course, I've also laid out the requirement under the NJC rule. So when I say merit, I mean people who have met those requirements. Under Rule 44A of the NJC rule, for example, there is a requirement for integrity, for knowledge, for all of those things. So the point is that I would not ordinarily expect that anyone will be appointed without meeting those requirements. But of course, there is always this divergence between the rules, which are usually clearly laid out, and then how people choose to enforce the rule. So I don't think that the problem that we have in our judicial system really is that of inadequacy of the rules, particularly with respect to specifying merit or what merit entails. I think the problem is those who enforce the rule and the manner, in which they appoint people. So those rules, if you ask me, they are actually not so complex. Like I said earlier, they can easily be met. So you have a pool of people or persons who have met a basic requirement. Then you move to the next stage, which is the rigor, in the selection process to ensure that of all those who are qualified, you only chose the best of the best. And I think that is where we actually get it wrong. Many people today, any lawyer, average lawyer, you and I, who has been qualified 10-year post-court to the bar, has met that requirement, unless there are integrity issue and all of that. But there is more to being a judge than that. So, but as an academic, I can speak that, for example, an academic exhibits certain kind of rigor with due respect, which I do not think those who are strictly in the practice do. I think those who in practice, with due respect again, they tend to lay back on the monotony of what they do. You go to court, you barely cram the rule, and you understand those things. It's technical, you understand the technicality. But it is the academic who actually engage in the intellectual exposition, intellectual, explanation of the law, because his motive as an academic is to decipher the law, decipher the meaning of the law, and then link it to societal problem and how to solve problem, ideally speaking. So if we have that in mind, and then we look for academics who have truly exhibited that or those quality through their teaching, through their research, through their learning, I think what we should do is to encourage those people by appointment onto our judicial benches. And like I said earlier, particularly on the Court of Appeal bench, because this is where the kind of exposition of the law, legal jurisprudence that introduces reform to the society. This is the court where they take place, at the Court of Appeal and then at the Supreme Court. So, but if you have people and they sit in panel, so where you have a panel that is broadly diversified in terms of the background of the judges themselves, the kind of robust judgments or reasoning that will proceed from such a court, can only be, I imagine.
Dr. Lateef, will you say you find, maybe in your own opinion, do you think academics being appointed as judges will be more suitable than legal practitioners being appointed? I'm talking about practicing lawyers being appointed as judges, if you have to choose between the two classes.
Well, like I said, I think what we should have in mind or bear in mind in making our appointment is, again, merits.
Yes, if we are talking about both of them, they meet the requirements?
Even as an academic, it is actually difficult for me to say that you will find more merit in the academic than you will find in the those who are into strictly legal practice. And that's why I may not be able to answer that question rather in a yes or no manner, you are trying to make me do. So I think merits exist both ways, and wherever merit is found. So I think what we should work on is not really a reform of our rules. The rules are actually very clear and they are very okay. I think what we should work on is the appointment process, the human beings who implement the rules, the human being who encourage the appointment with due respect of incompetent persons. And we have seen them around with due respect. The human being who encourage the appointment of people based on who they know rather than what they actually know, on kind of knowledge that they have exhibited. The human being who encourage people who appoint, their nieces, their cousins, their daughter, their sons. Of course, we have sons, nieces, cousins are qualified and openly so. They should be appointed. I mean, they deserve to be so. But what we have seen in recent time is that the system, with due respect, has really been, I would say, has really been abused, such that people tend to now, want to reproduce themselves with little or no attention to merit. So there are excellent legal practitioners in Nigeria who have really advocated reforms. I mean, they have promoted the cause of our judicial system, if you ask me. I mean, they've got judgments, and even where they have lost, landmark judgments that have contributed to our legal reasoning or development. And of course, you find them in the academic too. The current vice president, for example, Professor Yemi Oshibajo, I didn't want to mention it, but I think I should mention that, became, of course, was never a judge, but I'm saying he became the Attorney General of Lagos State, from being a professor at University of Lagos. And we saw the kind of landmark judgment that state, Lagos State, won at the Supreme Court between 1999 and 2000.
Hello, Dr. Lateef. I think your internet.
2006 can
okay, I'm hearing you again.
Are necessary, and bench of our court is one of them.
Okay.
Yes, and our judicial benches are, are just also one of those places where legal reform should take place.
Okay, good. Dr. Lateef, will you push for any amendments to the constitutional provision regarding requirements for the appointment of judges? Maybe if you can make reference to what we have in some other environments, in some other jurisdictions.
In truth, I've not actually given that a thought before now, but my attitude to constitutional development is that a constitution should stop at being a framework. A constitution cannot really specify everything. So, and I think the basic framework that the constitution has provided now, which is that you must be a qualified lawyer, you must have remained so that I think that is actually enough. So if I'm going to advocate for any reform at all, because the challenge with Nigeria is not actually absence of law. We have laws, we have rules virtually on all the ills or the challenges that have, bedeviled Nigeria. But the problem has always been the people who implement this law. So if I'm going to advocate anything at all, I think I will advocate that the process whereby those who become judges are required to appoint by themselves, we may want to review that. I think we should encourage deliberate appointment of fine legal minds wherever they are found, so that if there is a Professor ABC or Dr. NK or Mr. XYZ in a particular university whose scholarship, has reached such a crescendo or recognition that, it's a case of the truth or the fact speaking for itself, why should we wait for him to apply? Why shouldn't we just approach him and if we encourage him? That's what, happened to late Justice Teslim Elias. He was actually literally approached. I understand Rotimi William at some point and some other brilliant fine mind like that, Kayode Shofola, of blessed memory, were also. So my point is that if I'm going to advocate for any reform at all, it should be that we should not limit our appointment process to people who apply for themselves. we should deliberately scout for competent hands, whether in legal practice, whether in the academic, whether in corporate boardroom. For example, if there's a CEO of a company who has garnered so much experience on corporate law or corporate governance over the years, why not appoint them to the bench? The US Supreme Court, as I speak now, has at least 3 judges who came from the academic. The same thing in the UK, the same thing in Canada and other places.
Thank you, Dr. Lateef. I believe viewers have been really enriched by your opinions and position on this matter, which is well informed by your years of experience and practice. But on a lighter note, Dr. Lateef, would you have maintained the same position if you were not in the academics?
Honestly, I will have maintained the same position. I will have advocated that we should extend our dragnet, if I can use that word, of appointment beyond those who are in legal practice, particularly because of the history that I pointed to earlier, and even example around the world, all over the world, in the UK, in Canada, in US, and even in South Africa. Here in Africa, they actually literally appoint people from. But I must say that the debate as to whether legal academies should be appointed is not actually peculiar to Nigeria. They've had similar debates and they still have even in other jurisdictions. Because the truth is that the first instinct is to think that the only competent person is that lawyer who practices the law every day, who goes to court. So you don't really want to think that there are other, and the reality is that, like I said earlier, the trajectory of legal career is such that people go into different areas of law. So the fact that some people choose not to go into legal practice, they choose to be in the academy, or they choose to be in businesses, does not mean we should exclude them where they are competent and qualified to sit on our benches, as the case may be.
Thanks so much. I really appreciate your willingness to grant this interview. Thanks so much. I can't thank you enough. Thank you.
My pleasure, and thank you for the good work. Thank you, sir.
I really appreciate it. Thank you. Have a nice evening. It's evening here. I don't know time over there.
Well, in New York, this is barely 3 p.m.